Andy Murphy.
Always rushing the podium.
And we have our
Great. Good afternoon, everybody. It's a real pleasure to be here, especially all these very esteemed lawyers and practitioners. My name is Sandy Murphy, as Jonathan said, and I'm going to talk today. I tend not to stand behind the podium. We're going to get you trouble, aren't I?
Yeah, well, just the people out in the cybersphere.
Okay, cybersphere. We're going to
stand up just a little closer to the podium.
Is that good?
No, definitely.
I just tend to not like the podium because it creates a barrier, but I will go behind it if I need to. Just give me a high sign.
I think you're all right. You got to follow directions.
I'm a kinetic speaker, but anyway, is this okay?
Yeah, that's
Great. Okay, so I'm going to be giving you an overview of the debt collection provisions and some recommended best practices that have evolved over time, and that we often discuss with our clients about how they can implement the provisions of debt correction provisions of the WBCCPA and really limit or eliminate their liability. But before I get to that, Jonathan already alluded to this, there have been significant changes to the Consumer Credit Protection Act that many of us in this room were very involved in. In 2015, we did some significant changes, and I worked with Tony, Jason, of course, Jonathan, many long midnight sessions trying to get it right. We also had some changes again in 2017. At the time, there had been a significant shift in the legislature. We moved to a more conservative legislature. And that legislature tried to balance the important public policy of protecting consumers, but also with the public policy identified by that legislature of promoting business in West Virginia and striking a more moderate and measured approach to consumer protection without sacrificing that important consumer concern. So we worked on those in 2015 and again in 2017. As I was preparing for this presentation, I looked over some of the definitions, and I also looked at some case law. My colleague was here, and we had some discussions about what was evolving since the 2015 and the 2017 changes. And one thing I found very interesting is an evolving area of the law had nothing really to do with the changes that we made in 2015 and 2017. These cases, I'm going to talk about two of them today, really deal with these definitions that none of us changed. I don't think there were any significant changes to these. But there are two important cases I want to talk to you about, and then I'll move through my presentation and try to get to some of the best practices as well. But as I was preparing, I noticed a couple of things. And the cases that I want to talk about are a case that was brought by the Attorney General. It was the Copper Beach case that came out. It was against a landlord based in Morgantown. The other case was brought by the esteemed Jonathan Marshall, the People case, which I think, Jonathan, you may have just filed an appeal on that or filed some briefing on that. And again, since I don't follow the rules, Jonathan, I know you don't want anyone to talk, but if you want to jump in, I would welcome your participation. Please jump in if you want. But so let's first talk about the Copper Beach case. And let's just look at a couple of definitions here. This is what's going to be important. What is a debt collector? Very essential definition. Any person or organization engaging directly or indirectly in debt collection. What is debt collection? Any action, conduct, or practice of soliciting claims for collection or the collection of claims owed or due or alleged to be owed or due by a consumer. The word claims in these two cases I'm going to talk about that word is an important definition. And again, we didn't change any of these when we adopted the most recent changes. A claim. Any obligation or alleged obligation of the consumer to pay money arising out of a transaction in which the money, property, insurance, or service, which is the subject of the transaction, is primarily for personal, family, household purposes. That's a claim. So first, you got to be debt collector. And you're gonna be, and the debt collector is engaged in debt collection. Debt collection revolves around soliciting a claim. And I'll flip back and forth today. So let's talk about the Copper Beach case. This was a case that involved a residential landlord on Morgantown. And the Attorney General, this landlord under a lease, was able to charge fees 10 minutes. Oh, I'm getting a sign right. Okay. This landlord was able to charge fees. And the Attorney General made a case that this landlord was actually involved in debt collection. And that debt collection was an unfair and deceptive practice. Because if you were late, they charged a late fee. If you left your apartment a mess, they charged to clean it up. There were various fees. And I can remember when this case first came out, my first reaction was, are they even subject to the Consumer Credit Protection Act? Because when you think about who's subject to that, you're thinking a lender or a retailer. You wouldn't normally think of a landlord. So, but the Attorney General argued that the tenant was a consumer, the landlord was a debt collector, and that there was an obligation, looking again, an obligation or alleged obligation of the consumer to pay money arising out of a transaction, and the rest. So when I read it, I'm like, wow, it's not a bad argument. The lower court agreed with that. They said it's not a bad argument, but there is some ambiguity around the word claim. And they certified question up to our Supreme Court. And our Supreme Court, in construing this case, looking at it, anyone can join in here. I don't know if you were involved in this, Anthony. No. Did you brief? Oh, you are. I'm moving too much. Okay. All right. Sorry, guys. And so the Supreme Court had to look at the issue. They looked at the certified question, and since I only have a few minutes left, they concluded that there were, if the legislature had intended that landlords would be covered by this, and again, the Attorney General was trying to expand the application of the act, then they would have explicitly said it. And they pointed to other sections in the Consumer Credit and Protection Act that do actually address residential leases as being part of it. There's a section, a tiny section, and the court in its holding says, remember that there is a tiny section that expressly refers to residential leases, and it is the plain language section. So if you write a lease, you better do it in plain English. But otherwise, they refuse to expand the scope to landlords. Because if you look under West Virginia law, there are myriad sections of the code that deal with the landlord-tenant relationship, and they refuse to expand this. Query the recent case against the Catholic Church, that our state attorney general is trying to expand the application of the Consumer Credit and Protection Act under the unfair and deceptive practices sections of the code. The attorney general is making the argument that the Catholic Church failure to do background checks and other things comes within the Consumer Credit and Protection Act. So I thought I was going to be talking to you only about best practices, how they've evolved since our more recent changes to the act, but this has nothing to do with that, and it is a current definition in the act that they're seeking to expand. And the court, again, the court actually also looked back at general provisions where there is a definition called a consumer lease, and the court concluded, if you read it, the consumer lease only applies to goods. Consumer loan is a loan. A consumer sale is a sale. So they refused, our Supreme Court refused to expand the definition to include a landlord. Okay, the second case, Jonathan, is the Hinkle case. Now, I'm just going to say, I read this case, and in working with you guys on the changes that we did, and that was rough going days at times. But I wanted to say to Sarah Brown, I don't know if she's here, but I also was locked in a room many years ago working on changes with Dan Hedges to certain sections of the Consumer Credit Protection. I would rather have all of you than be locked in that room with Dan. And you can tell, please tell Sarah, because Dan will understand. He will totally get it, so he'll not be mad at me. But we spent a lot of time working through some of these changes, and I've done that on behalf of the industry. But in working through these, I really have a lot of respect for our plaintiff's bar and the excellent practitioners that are on that side of the breed. And Jonathan, I have to say, in reading the Hinkle case, I was like, wow, I would never have thought of this argument. I don't have much time left. But it's a pretty interesting argument. It's very innovative. You are wrong, but it is good. So Jonathan brought a case. I'm going to go back. Okay, well, we're here at the claim. About gap insurance. I'm going to make this quick. On gap insurance. And it's a product that gets sold to fill the gap between your insurance, say on an automobile, a car, and what you owe the bank. And in this case, the provider of that insurance agreed that they would pay, I think it was $5,000 as opposed to the $11,000 outstanding on the debt, because the borrower had not paid timely and had incurred additional, fees, penalties, late fees on the outstanding debt. And so they said, no, our contract was just for the $5,000. You did things during the course of that you can jump in if you want, that made that amount, that outstanding balance on the loan increase. And so we are not going to pay that. So Jonathan had a really interesting argument. Do you want me to do it for you? Or? Okay. So does the sale of gap insurance give rise to a claim? So let's go back. Whoop, am I going back? Okay. So, and because he wants the insurance provider to be under this act, because then he will be able to do what Jonathan does. He does very well. So he wants him to be a debt collector. Any action, conduct, or practice of soliciting claims for collection or in the collection of claims owed or due or alleged to be owed or due by a consumer. So the question is, do we have a claim? Is there a solicitation for collection of a claim when it's a one-time transaction? So, for instance, I go into the grocery store or the Rite Aid, and I go up to the counter and I say, I'm at the point of sale, and I say, I'm going to buy that coffee cup. You tell me how much it is. I pay you. I walk out. By analogy, a person buying gap insurance comes in, we sign a document, I pay my amount, and in my mind, that's a contract. It's done. In Jonathan's brilliant mind, I really thought it was a good argument. You are wrong. But he takes this and he says, can I get a claim out of this? So let's go look. Any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, it was a good thing he had the word insurance in there, or service, which is the subject of the transaction, is trying to blah, 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 basically a consumer. And so Jonathan is arguing that we actually have, at that point of sale, a solicitation of a claim. Yep. You want to? And Judge Copenhaver, who I know you've been through, I looked from the pleadings that you've been there a couple of times before Judge Copenhaver basically said, not working for me. He basically said that really it's a contract. It's a one-time point of sale contract that's created. There's no solicitation of a claim. Do you want to rebut this in any way or anticipate your? But again.
I think he had to reconsider it the first time.
There you go. Yeah, he had to reconsider because it's something that was going on in the Fourth Circuit, I guess in the Third Circuit. But anyway, so my point here is, and I know I'm out of time and I really do apologize, but as I was preparing, I just thought it was pretty interesting that on the forefront of this are really practitioners who are trying to push the limits. One of those people happens to be our Attorney General, which I find really interesting because the unintended consequences, Mark, of saying that the Catholic Church, thank you, is subject to the Consumer Credit Protection Act. That leads to other things that other people, other institutions that you wouldn't really think it would cover. Could open a floodgate in a way that we're not really interested in opening the floodgate. So to me, this is just an interesting development to see it attempts to apply the act, which is over 40 years old. It's over, I think it's 42, 43 years old. and as its classic application has been in much narrower context. It's just an interesting development, I think, here in West Virginia. So I'm going to give you homework. When you go home, please look through what I didn't present to you. And the caveat is if I ever see any of your briefs, quote me on any of the things that I recommend to clients, you're in big trouble. And you know I will come get you. So anyway, thanks everybody.